Welcome to Court Helicopter Explainer, the third episode that is dealing with the question of employee and employer. This is on the question of the hours of work. Are you being overworked? We have got to look at it. But more than so, are you a woman? Have you ever been pregnant and your employer tells you, don't come back? Have you been sacked because you are pregnant? Have you been given maternity leave? How many days are you entitled to go on maternity leave? How many days are you entitled to go on an annual leave? Do you mean when your wife is expectant? What happens? Are you also entitled to paternity leave? Wakili Dan Sanomari brings it as it is. Stop hearing what people say. Follow what the Kenyan law says. That is the Employment Laws, Chapter 226 or Cap 226 of the laws of Kenya. We'll start with what we call Section 26 of the basic minimum conditions of employment. We go to Section 27, hours of work. What does the law say about the hours of work? An employer shall regulate the working hours of each employee in accordance with the provisions of this Act and any other written law. So, you work for 8 hours. The Kenyan Employment Act provides that you work for 8 hours. But those 8 hours can be staggered. For example, if you are working in a factory, you can do an 8-hour shift, another 8-hour shift, another 8-hour shift. Anything above 8 hours must be negotiated and is called overtime. 2, how many days are you supposed to work in a week? The law says an employee shall be entitled to at least 1 rest day in every period of 7 days. So, you now know. Stop telling your employer you work for 5 days. The Employment Act provides for 6 days and 1 day to rest. That is the law. You employers, do you give your employees 1 day off? The house girls, remember house girls are also employees. Do you give them a 1 day off, or they work for you 7 days a week? The houseboys, the drivers, do you allow them a 1 day off? Wakili Dan Sanomari has brought you the law that 1 day is mandatory as a rest day. Let us deal with the question about the annual leave. What about the annual leave? The annual leave is that an employee shall be entitled after every 12 consecutive months of service, not less than 21 working days of leave with full pay. Per year, as an employee, if you have worked for the whole year, you are supposed to take a minimum of 21 leave days. 2, those leave days must be paid for. So don't be told that we can't pay your salary because you are on leave. When you are on leave, you must be paid full salary. 2, if you are sacked before the 12 months are over, what does the law say? You are supposed to be paid not less than 1 3/4 days of leave with full pay in respect of each completed month of service in that period to be taken consecutively. If you have worked for 3 months before you qualify, for every 1 month completed, you have 1 3/4 days of leave. For every month. So if you are sacked midway and you have worked for 8 months, the HR will calculate, because for every month that you work, you have 1 day and 3/4 of a day as your leave days. Then it goes on to say, now let us deal with the most contentious one, maternity leave. This one, I'll be forced to read the law as it is, because this is the most important one. A female employee shall be entitled to 3 months maternity leave with full pay. So for ladies, when you are expectant, you shall, the law says you shall be entitled to 3 full months maternity leave with full pay. So anybody telling you go and deliver will not pay you, or we give you 20 days, or we give you 1 month leave, that is illegal and unconstitutional. It's 3 months leave with pay. After you have been given 3 months leave, the leave after expiring, are you entitled to the normal annual leave? Yes. So a pregnant lady can take 3 months and also another 1 month of annual leave. And that is why this is going to be 4 months. Are we counting the weekend? No. They are working days. 6 working days. Every 1 day is removed, because, and that is why you see when a mother goes for leave, 3 + 1, 4, if you calculate, you remove the weekends, you remove the public holidays, she will be going on leave for 5 to 6 months. This is to allow her take care of the young child, breastfeed that child, make sure that that child is well nourished before the mother comes back to work. So, number 7, no female employee shall forfeit her annual leave entitlement under Section 28. So, they cannot forfeit their annual leave because they took a maternity leave. Then, the notice to go for maternity leave must be served 7 days in advance. So those mothers who are expectant, you want to go on maternity leave, you must give your employer a notice of at least 7 days. That notice, you must attach a doctor's report or a midwife's report showing that you are going on maternity leave, and the doctor has told you when your due date is going to be. What about men? Are men also the fathers, the husbands? Are you entitled to leave? Yes, not maternity leave. It is called paternity leave. Let me read. Section 8. A male employee shall be entitled to 2 weeks paternity leave with full pay. So, if your wife is going to maternity leave, as a husband, as an expectant father, you are entitled to 7 days paternity leave with full pay. Employers, when a husband tells you or a father tells you he is applying for paternity leave, take it. Men, don't feel ashamed that you are on paternity leave. You are supposed to be there to take care of your expectant wife, to take care of the child that is going to be born, to provide logistical support. And that is why the law has allowed you 7 days. Don't ask whether it is a constitutional or not constitutional. It is illegal or not illegal. Court helicopter brings you the issues as they come. Another leave that we talk about is what is called the sick leave. Very many of you have fallen sick and you call your employer by phone. I'm unwell. I'll not be able to come to court. Kumbe, you drank yourself the whole night and you forgot to come to duty. What does the law talk about sick leave? You are entitled to a sick leave with full pay. You are entitled to a sick leave or full pay for a period of a maximum of 7 days. But you must bring a medical cheat, a doctor's cheat, showing where you are. If you exceed the number of days, then you will start earning half the salary. Let me read this so that you understand what I'm saying. After 2 consecutive months of service with his employer, an employee shall be entitled to sick leave of not less than 7 days with full pay, and thereafter to sick leave of 7 days with half pay. The first 7 days, you'll get full pay. The second 7 days, half pay. In each period of 12 consecutive months of service, subject to production by the employee of a certificate of incapacity by a medical doctor. So, if you, in 1 year, you have 14 days sick leave, 7 full pay, 7 half pay. After that, you'll go on leave without pay. Mark my words very clearly. So, remember, being absent without permission, being absent without medical conditions, we shall be dealing with it, because under section 44, which we'll be dealing, is a ground for you to lose your job. Then we have what we call housing. Depending on the nature of your job, under section 31, your employer is supposed to provide for you housing, house allowance. In your calculation of your salary, housing must be part of it. Either you take a consolidated salary that puts in medical, housing, everything together, or you negotiate an item separate for housing. Your employer is supposed to give you house allowance. Your employer is supposed to provide housing for all the employees. Then it moves on to say, an employer shall at all times at his own expense provide reasonable housing accommodation for each of his employees, either at or near to the place of employment, or shall pay to the employee such sufficient sum as rent in addition to the wages or salary of the employee as will enable the employee to obtain reasonable accommodation. Your salary is separate from rent. So if you ask your employer, is he giving you a consolidated salary? That is salary, that's the wages and house rent. What section 32 provides that where you are working, the place where you are working, in a factory, in an office, wherever you are working, it is mandatory for the employer to provide water. Are you told to buy water? You come with water to your office? No, the employer is mandated. Let me read it. An employer shall provide sufficient supply of wholesome water for the use of his employees at the place of employment, and as the case may be, within a reasonable distance of any housing accommodation provided for the employees by the employer. So, if you are staying in a house provided for by your employer, he must provide water. Wherever you are working, that office, that shop, that cyber office, that boutique, that water must be, drinking water must be provided by the employer. What about food? Section 33 talks about an employer shall, where the provision of food has been expressly agreed to at the time of entering into contract of service, ensure that employees are properly provided for food. These are hotel workers under the CBA. All employees of hotels are supposed to be fed by the hotel. What about medical attention? Subject, an employer, that's section 34, an employer shall ensure the sufficient provision of proper medicine for his employees during illness and a possible medical attention if it is of a serious illness. So, all those are rights under what we have said, part 5 of the Employment and the Employment Act. Now you know your rights of maternity, of leave, and the others. Okay, Dan Stanomari telling you this is the 3rd episode. Keep watching as we go to the 4th episode, still on the question about employment. Thank you.